Ross, you always can calm down a room. It's pretty great. You should see him in faculty meetings. It's great. In any event, I'm Anthony Crowell, the Dean and President here at the Law School, and I am so excited to welcome all of you to our City Law Breakfast. And with a wonderful speaker today, Zach Carter, our new Corporation Counsel. And thank you, Ross, for putting this together. As always, our Director of the Center for New York City Law. And our City Law Breakfast, I think, are a mainstay of this institution and one of the reasons that we are so proudly calling ourselves New York's Law School these days. As many of you know, I personally started my career at the Law Department 17 years ago, and it was among the most exciting and wonderful experiences of my career, and I don't think I would be here today without that experience. And I think there are so many Law Department attorneys here, alums, and it's really heartwarming to see that New York Law School's presence at the Law Department is probably either first or second among representation of all the area law schools, and that's something we're very proud of. We're also proud to say that a number of our students are going to be working there next year, including, I see Alex Noble, who's sitting at the Corporation Counsel's table. And we've had wonderful partnerships over the years, especially this year with our new Municipal Litigation Defense Clinic and our clinical year. And we're very proud to work with the Law Department and serve as a pipeline to the Law Department. I'm going to ask Ross to come up and give a formal introduction to Zach, but I just want to offer a personal note that I got to work with Zach a little bit in my role at City Hall, where I served as counselor to Mayor Bloomberg before joining the law school, and Zach was the chair of the mayor's committee, advisory committee on the judiciary, and did such an extraordinary job, and was someone that the mayor really relied on. And it is really fitting that he moved from that position after such a distinguished career, both in public service and in private practice of law, to being corporation counsel. With that, let me ask Ross to come up and offer some other welcoming remarks, but we are so pleased that you are all here and look forward to a lively discussion this morning. And Ross, there you go.
Thank you, Dean Crowell. It's wonderful that he's here because it really reinforces what we want to do with the Center for New York City Law. This is really an important breakfast for us. Over 400 people RSVP'd. They wanted to hear Zachary Carter. They wanted to meet him or to talk, to hear him, and to sort of get a sense. And that's what these breakfasts are designed to do. Zachary Carter has had an extraordinary, diverse experience. He was an assistant U.S. attorney in the Eastern District, U.S. attorney in the Eastern District, a magistrate in private practice, has held important positions and boards on the public interest side. As you heard, was the chair of the Mayor's Committee on the Judiciary. In his work as U.S. attorney, prosecuted very important cases, the prosecution of the perpetrators of the Yanko Rosenberg murder, of prosecuted Vincent Gigante, those who perpetrated the Abner Louima tragedy. And in all of that has demonstrated the kind of character and integrity that we have come to expect of the Corporation Counsel. In preparation, I went back and I looked at what Mayor de Blasio said at the time that he announced Zachary Carter's appointment. And what he said was that Zachary Carter would be the conscience for the rest of the government. And that's exactly right. I've had the good fortune of knowing all of the Corporation Counsel, people who've held that positions as Norman Redlick. And what was true of all of them was that they felt that keenly, that they were the conscience for the government, that they were not just the litigators, but they were the counselors as well. And that's what Zachary Carter brings to this position, and we are delighted to welcome him to New York Law School on this podium.
Good morning. It's It's a lot of pressure being somebody's conscience. I was raised Catholic, but I am not the Pope. But thank you very much, Dean Crowley, and especially I'd like to thank Professor Sandler and New York Law School Center for New York City Law for inviting me to address you today. As Professor Sandler knows probably as well as anyone because of the years he spent in city government, when you're in city government, you're so busy doing what you're doing, you haven't got time to think and reflect on what you're doing and the ramifications that what you do has on the lives of ordinary people and on institutions of government. And for that reason, the center here at New York Law serves an extraordinary purpose in the scholarship that it produces about the operations of city government and the forums like this that it puts together so that we can have discussions about how city government operates or how it should operate. So I congratulate Professor Ross on the establishment and the continuance of this center and this forum. Now, yesterday marked the 100th day of the new mayoral administration. Now, although I did not take office officially until February 1st, I have been hovering around the law department since about January 1st. Indeed, after a string of all-day visits in early January, the senior folks in the law department decided that I was making enough of a nuisance of myself that they might as well stick my name on the door and give me a BlackBerry and a phone and a secretary. And so I've been there ever since and have had just an extraordinarily welcoming relationship with people who have worked in that office for several decades with great skill and loyalty. And as a matter of fact, I can finally take this occasion, particularly since there's so many of you here, please stop the resumes, all right? Because I haven't met anybody, there's 730 people in the law department, I haven't met anybody I'd want to replace. So you just slow it down. Slow it down. Okay. Now, I've been asked to discuss, and I'll take a few minutes discussing my vision for the law department, and because I'd like to spend most of the time having a free exchange with you, but I'd like to talk about some of the things that I had thought about coming into the law department and how some of my beliefs had been challenged by the reality of the actual matters that I've been confronted with, some of which you may know about from reading the paper, and some are extraordinarily important but way below anyone's radar screen, because that's what these 730 attorneys do day in and day out in the widest variety of issues imaginable. They do the important work of providing legal counsel and advocacy for an extraordinarily complex corporation that is the city of New York. The issues that cross my desk are so incredibly varied, it's hard to describe it. I can only say that I have not used tax and certiorari in the same sentence since the bar exam. I actually had on my desk 3 days ago the 2008 regulations governing blood testing for TB in elephants. You know? You do not want an elephant to sneeze on you that has not been tested when you go to the circus. So it's, you can't make this stuff up. I mean, on a typical day, I will review legal matters affecting transportation, schools, you've heard about schools, public safety, including police, fire, and corrections, housing, public health, taxes, labor law, real estate, municipal finance, and more torts than you can shake a stick at. And practically every policy issue that issues from government has some legal implications, and virtually every legal issue that we deal with has important government implications. As one of my predecessors and a dear friend, Peter Zimroth, has written, the law department lives in an intersection of law and policy. Now, I came to this position with a point of view about the mission of government lawyers generally and the mission of the law department in particular. And I was open-minded. I thought that it's possible that my point of view might change, but there's a difference between being open-minded and empty-headed. You know, I mean, it's if you've lived on the planet and you've had experience, you're going to have a point of view. But if you are reasonably humble about yourself and your capabilities, you should accept that there may be things you didn't know, facts you haven't taken into account, or an argument that you haven't heard, or an experience you haven't encountered. And so that point of view gets tested. So I'd like to share some of those presuppositions that I've had and talk to you about whether or not they hold up or not. Now, fortunately for me, this was not my first rodeo when it came to supervising government lawyers in the practice in civil practice. When I was U.S. Attorney for the Eastern District of New York, a large part of my responsibility was supervising a civil division of lawyers who, like the lawyers in the law department for the city of New York, represented the agencies of a different sovereign, the government of the United States. And it was there that I formed my view of the special character, the special responsibilities, unique responsibilities I believe that government lawyers have, particularly when they're engaged in civil practice. You know, particularly when you are in litigation, you are, whether you're working for the U.S. Attorney's Office or working for the City of New York, you are bringing and you are defending cases in the name of the people, the citizens of a sovereign. In the case of the United States, you're bringing cases or defending cases in the name of the people of the United States. And in the case of New York City, we're bringing or defending cases in the name of the people of the City of New York. What's unique for government lawyers, though, is that the people on the other side of the V, the individual or the institution, is more than likely than not some subset of that broader group, of that sovereign. So you could be said that we are in gentle conflict in almost every litigation because of someone on the other side of the V is also one of the citizens of the City of New York whom we represent. And I believe that because of that position, that we as government lawyers can never be indifferent to the fairness of the ultimate outcome of a litigation or a transaction. Not everybody agrees, but it's great to be king. But most people agree in my office. I say that. That in the time that I have been there, this is something that to which all of you can take judicial notice, even those of you who aren't judges. We've had lots of situations in which the law department has been confronted with the challenge of aligning litigation positions with reversals in policy, and that's what we're there for. Our client is the City of New York writ large, and in our democratic process, I know it's become cliche because it gets said so often, but elections have consequences. And one of the consequences of those elections is the people speaking through the process of the ballot box make policy choices. They select people to represent them, particularly in the executive branch, particularly in the office of mayor, who has spoken to their aspirations in a way or who has promised policy changes that reflect their views, and that's how they cast their ballot. And so it's the prerogative of the elected chief executive to set a new policy course when he or she thinks it is warranted, and it's the job of the lawyers of the law department. We have a responsibility to provide the legal architecture or infrastructure to support those new policy choices whenever we believe in good conscience that the law can't permit that. Now, there's some situations in which a new executive may propose something that, in our view, we reach a consensus is just legally flat impossible. But more often than not, since we are all lawyers here, and since we know this from law school, we were trained that to be able to argue with equal force either side of any debatable proposition, we know that those situations in which there's only one compellingly right answer to any legal proposition are rare. And therefore, we have to very often put our thinking caps on to figure out a way to adapt to a new policy reality. And I think that with a lot of work and a lot of imagination, we've managed to do that thus far, knock wood. And we expect to continue. I think that sometimes when people think about the law department, and some has been written and people have given talks about it and the like, we think of one of the hallmarks of the law department is independence. And I think that's true. I think that the law department is justly proud of its longstanding reputation for being independent from politics. I mean, the first thing that lawyers should do is determine what they believe through their research and analysis, what the law is or should be, what is the best legal basis for decision making, to either defend a claim or a case or to bring a claim. But being independent from politics is not the same as being independent from policy. To be independent from politics is noble. To be independent from policy is arrogant. Because we are not a bastion of decision-making unto ourselves. Nobody elected us to public office. We are the lawyers for those who are elected to make policy, and that's our job. Now, we will push back hard. I think the mayor was quoted yesterday in the Times as having said that I was one of two members of his senior staff that were permitted to be contrarians officially. I'm going to hold him to that, but I won't take it too far. So there's going to be times when we'll have to push back hard when policymakers are going to want to do something that's just not reconcilable with the law in its current form. Perhaps it will be a situation in which we will have to recommend that there has to be a legislative fix in order to accomplish this, a policy purpose. And so we will fulfill that function. But we won't do it lightly. We will, whenever we can, try to find a way to support the policies that our elected leadership have been asked by the electorate to implement. One thing I feel pretty strongly about, and I've certainly had enough exposure to it in terms of the number of matters that I've had to take a look at over the last 100 days, and that is a courtroom is a very poor place to make public policy. And what we would like to do to the greatest extent possible is to try to help agencies, to help the mayor's office whenever possible, and at the earliest time possible, when we sniff out that there is a controversy that is now either threatened or pending in court, to get people around a conference room to resolve it rather than before the bar. As you know, those of you who are litigators, our tools are very, very crude. We have sledgehammers and meat axes in a courtroom, and very often, in order to make policy, you need scalpels. We don't have them. And so I think we will try as best we can to use our influence with our clients and our clients' constituent groups, our agencies, to try to encourage policy formation in a way that's orderly and more effective. And lastly, in terms of the things that I had thought that I would like to do, and that I think that I'm still certain that we need to do, is to take advantage of the fact, to an even greater extent than we do now, of the fact that the law department is really a canary in the coal mine for any number of problems that arise in government. Generally speaking, if there is some employee of government, or if there is some policy of government, if there is some recurring problem that's giving rise to litigation, the law department is going to find out about it first. In private corporations, there are generally, well-run private corporations, there are robust risk mitigation organizations. And when they see these recurring themes, they start to give feedback to operating units as quickly as possible so that these problems don't recur, so that you can reduce litigation by making sure the problems don't recur in the first place. And so we're in a unique position to gather that information. And quite frankly, in our torts division, we're doing that already. And there are very few original ideas in this world. I thought I had an original idea. I didn't. In the torts division, they're doing that, and we want to spread that around the entire organization and become kind of the risk management organization for the city. So with that, I will open up the floor to questions. And because I've only been, okay, thank you. Oh, sure.
We have microphones over here, and if you go to the microphones, we'll take it on either side. And while people are coming up, I'd like to just thank the sponsors of these breakfasts, Greenberg Traurig. I very much thank you, and you have a table here of people from your law firm. Con Edison and Verizon have been our regular sponsors of these programs. One other thing, on your table is a copy of city regs. Now, we haven't covered the elephant regulation yet, but what we do is we give a synopsis.
That's an example of one we nipped in the bud.
Oh,
so
good. Well, it won't be on our, but every 2 weeks we send this out to subscribers so they don't have to read the city record. We do it for them. So if you're interested in avoiding reading the city record, this is your publication. Questions? Please, it's hard to think that this many lawyers would, only one person would stand up. Okay. So this will get us going. Over here. Yes.
Mr. Carter, thank you for speaking with us. The mayor has stated that what he envisions is a broad rollout of broadband communications. And if you could discuss from the legal end, how will your legal policies differ with respect to the Telecommunications Act from those of your predecessor, including related to barriers to entry, Section 253 in particular?
Sure. Fortunately, I can say, because it's one thing is one less thing that's on my plate, that right now the person who is with the support of the law department, who is focusing on broadband in all matters relating to broadband, again with the assistance of the law department, is the mayor's counsel, Maya Wiley, and so I am not as conversant with the details of it, but I know that in terms of the policy is to try to encourage the carriers who have the pipe to provide access as broadly as we have the leverage to induce them to provide it.
This side.
Morning, Rick Schaefer. I want to preface this question by assuring you that Ross Sandler did not put me up to this question. Past corporation councils, with the best of intentions, have entered into consent decrees that over 20, 30, even 40 years continue to constrain the city in policy making in ways that often don't make sense and sometimes even are detrimental to the interests of those whom the consent decrees were originally designed to protect. How would you avoid that?
Well, it's nice to have one box you can check off. You'll notice that, and this is a matter of public record, that in the stop and frisk resolution, which was the first settlement that at least the one that had public attention that we arrived at, that we reached an agreement with the parties to limit the monitorship to 3 years of substantial compliance, and the overall court supervision to 2 years beyond that, if there was substantial compliance during that period. So we take it very seriously that we would like to limit the duration of these decrees, because quite frankly, I think it puts the kind of pressure that sometimes we need on ourselves to come into compliance quickly, to demonstrate that we can sustain it and that we can relieve ourselves from restrictions. Because, you know, there's so many laws of physics that have analogs in the law. You know, they say gas fills all available space. If you have a decree without limit, I don't think things get done as quickly or effectively. So.
Good morning. In your speech, you mentioned that when it comes to claims, you mentioned that courtrooms aren't a good place to make policy, and you recognize the need for basically more resolution outside of the courtroom. Do you see that being true for claims that aren't so connected with policy, kind of day-to-day claims against the city? And I was wondering if you could talk a little bit about how that might affect individual city attorneys' approaches to resolving claims.
Well, I think we're always searching, and particularly in the area of torts, for carve-outs of claims of a certain sort that can be treated as in something more like a claims adjustment process. I mean, if you have something that's recurring, and the discovery is relatively simple in terms of volume and kind, and it's repetitive, and it's something. As soon as you read the complaint, you kind of have a sense of you've seen this movie before. You kind of have a sense of the outcome. That's something that you want to divert that away from active litigation into something more like a claims adjustment process. And the torts division has been doing that for long before I got here. And so, and I think we're going to try to do that as much as we can, because it saves our resources and it saves the resources of the city.
Hi, Carolyn Kubitschek from Lansner and Kubitschek. I have a question about, I guess, openness and transparency. In civil rights cases against the police and other government officials, there seems to be a new practice, if not a new policy, that the corporation counsels on the case will not agree to file the settlement in court, so that the only people who know how much money has been involved are the litigants themselves. And I'm wondering if you'd care to comment on that policy.
Well, I'll be honest with you, I have not focused on that personally. There's no one who's brought that to my attention as an issue. You have, and so I'll take a look at it.
Thank you.
Good morning, Mr. Corp Counsel. This is Sal Russo. I'm General Counsel at HHC.
You look familiar.
Yeah, I know. I'm going to give you a softball, which is, I'd like an
Thank
opportunity.
you.
You're welcome. Remember that when I come to see you.
Yes, I will.
I was wondering if you could.
Softball, right?
Yes. I was wondering if you'd like to share with us what your top agenda items are for your administration at the Law Department.
I guess for me, I've pretty much. I guess my agenda items are at this stage more of an abstraction, and I've kind of outlined them in terms of my philosophy of what government lawyers should do in some. And I think that it's not as if that requires a sea change, because I think that we have extraordinarily smart and capable and fair lawyers who kind of come to the same thing by their own instinct, and it hasn't been a hard sell at all in terms of just taking into account whether or not, notwithstanding the fact, for instance, in a particular case, we may have all the law on our side, but when you look at the ultimate outcome, it just stinks. All right, taking that into account and trying to come to some resolution that makes sense, that respects our obligation to the city to limit liability, but perhaps there are those extraordinary situations where some matter of nominal damages might be suggested by the equities. Trying to do that as often as makes sense is one of those kinds of things. Again, trying to identify all those areas in which we should be the Maytag repairman, where we are engaged in litigation that everybody's shaking their heads on both sides of the V. Why is this even in court? Trying to focus on those areas and trying to to reduce those, both in the area where policy is being made in a courtroom and in the area where you have these recurring claims being brought against agencies, where if you can bring the agencies in and talk about avoiding this recurring practice in the long run, you can reduce the risk for the city and reduce payouts over time.
Thank you. I see you taking your conscience role very seriously.
Yeah, thanks. Oh, sorry.
Good morning, Mr. Carter.
How you doing?
My name is Michael Bennett. I'm a student here at New York Law School in my second year. I'm in the clinic that Dean Crowell set up, and I'll be in the summer program this summer at the law department.
Great.
I was wondering if you could offer perhaps 1, 2, maybe even 3 pieces of advice for a young, soon-to-be attorney like myself entering the law department.
Well, I think one of the things that you're going to have the good fortune of is that because the office is so busy. I remember when I was in the Brooklyn DA's office, there was a good friend of mine there who was who used the phrase "good hallway lawyers" to refer to folks who talked a good game about trial, but they hadn't really done it that much. You're not going to run into too many hallway lawyers at the law department, and you have the prospect of really getting some really valuable experience. I had the good fortune to attend a meeting of a high school team we represented in moot court competitions, and not only were the kids outstanding, but their supervisors, who were themselves pretty young attorneys, were just incredibly impressive. They weren't just providing, generalized kinds of advice. I mean, they were helping these kids in high school understand concepts of laying foundations and exceptions to the hearsay rule that you would expect to be learning here. So I mean, I think you're going to get a first-rate experience. And it's really about getting into court as often as you can to actually watch the process. But also, when you go to court, the one thing that's important is that when you observe someone, sometimes appearances can be deceiving. You really have to, and everybody will be receptive to it, collar them after they're out and find out why they did what they did. Because sometimes seeing it and not knowing the reason why someone is taking certain steps in the courtroom won't be as helpful as quizzing them afterwards. But you're going to have a good time this summer.
Let me interject a question related to that. Some people who were corporation counsel litigated themselves and others didn't. Are you of a mind to go into court yourself? You. I'm talking to you.
I thought you were talking to him.
No.
I know he wants to go into court. Yeah. If the right opportunity comes up, I'll do it. I know that there are times when people feel the need to create an artificial opportunity to do that. I was squeamish about that as U.S. Attorney. I've tried lots of cases, and I enjoy trying cases, but when you show up and you're not saying, oh, I'm assistant corporation counsel in the name of blah, 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 you're saying, I'm the corporation counsel, that's consequential. And you have to be very, very careful about when, I think it's less of a problem when you're arguing appeal, and I think that's not as big a deal. But when you show up to try an individual case, and that thumb's on the scale, I'm not so sure, but I'd be tempted.
Good morning. I'm an alumni of this school, and thank you for coming to speak to this group. I also am an alumni of the law department. I worked in the family court division for 7 years, and now I work for legal aid. So,
and one of the things that I found mystifying after the last 3.5 months, when you're dealing with all the myriad of issues, the fact that we operate the family court division in our spare time, that we're the chief prosecutors of juveniles, is just kind of boggles the mind.
well, that's my question: is like, what plans do you have for that division? I've worked in Jamaica on both sides, and two of the people from your office are here who I've worked with for a long time.
Sure.
But there's a lot of changes in juvenile justice right now, and there's raising the age, there's close to home, What's your focus going to be on that?
Well, I mean, I think that one of the things that we always have to remind ourselves when you're prosecuting cases in family court is the core values of the Family Court Act that make it different from the penal law. I mean, there's a presumption of finding the least restrictive disposition consistent with public safety. There needs to be, in my view, always a greater focus on finding effective programs that divert kids from the pipeline around success to jail. So we'll certainly be focusing, have a renewed focus on that.
Well, let me ask a question. I urge some of you, I see so many people who've been at the law department, litigated cases for the last 30 years against the law department. You must have some. This is an opportunity. But let me ask.
Not about a pending case.
Not about it. But let me ask you about a case that you brought up, the stop and frisk, and the fact that you have worked out a settlement. I wonder if you could expand on that. How do you see working with the monitor? How do you see working with the police department and the plaintiffs in that case? And what would you judge to be the kind of results that you would like to see come out of that period?
I mean, what's interesting about stop and frisk is that to a large extent we have I think a smart procedural framework that was developed by the district court judge that provides a lot of flexibility, provides a lot of input from all kinds of stakeholders, including the police department, of course, the law department, plaintiffs' counsel, and representatives from the community. The irony, of course, is that stops have been reduced so dramatically that to some extent it could be argued that a large part of the problem has been solved. It doesn't mean that there isn't still a need for vigilance. But when you have close to 200,000 fewer stops year over year, you don't have the same degree of problem that we've had in the past. But some of the challenges of making sure that stop and frisk is applied properly and not inappropriately is first you have to make sure that police officers understand the law and understand what the constitutional limits are, what the requirements under Terry are, and because Terry is in some respects more difficult, I think, to define and has a greater degree of subjectivity and obviously a lower standard of proof. It sometimes creates a greater challenge than probable cause, which is a bit more bright line under most circumstances. And then you have the issue that really bedeviled and was the core concern of most minority communities, and that's the issue of race. You know, when is race taken inappropriately into account? And that is something that we're going to be spending a lot of time with the police department focusing on to make sure that race is only a factor in any stop to the extent that it's descriptive with respect to a specific crime or membership in a particular criminal organization, you know, a crew or a gang or something of the sort, and not a product of stereotyping based on broad crime statistics that indicate an overrepresentation of a particular demographic in a particular crime category. That in of itself will not justify a stop, but particularized suspicion will.
Good morning, Mr. Carter. First of all, congratulations on your appointment.
Thank you.
And for continuing in the noble pursuit of the public good, which you've done for many, many years, and that's indeed commendable. The speaker, or the questioner before me, spoke about family court, whereas you know, in addition to the attorneys who work directly below you, there are also many attorneys who work for the Administration for Children's Services, Family Court Legal Services. And basically my question deals with your view on attorney retention, both within Corp Counsel and within the various agencies that provide the backbone, the knowledge of the particular regs and how the agency works for when your attorneys need to litigate.
Well, one of the problems of retention is that you know, our attorneys who work very, very hard are entitled to earn a decent wage to support their families. And it's been a while. You know, we have a senior attorney program that gives us some flexibility in providing raises, but you know, half of our attorneys haven't had a raise in 10 years. So write your councilman, write your, you know, that presents a challenge. And I'm not personally, I don't know what the challenges are unique to ACS. I would guess that they're similar, but I know that in the law department, particularly in family court and in torts, I'm surprised we don't have more turnover than we do. We have some people who are incredibly dedicated, and I know have to be laboring under some strain financially, but they hang in there, you know, and we get less turnover than you might imagine under the circumstances.
Well, it happens to be very high at ACS. I mean, there's virtually no support staff. There's difficulty getting any sort of overtime, a lot of issues. So, and in addition to the high student loans, is there some student loan program, for example, that the city could work towards? Because that's also a major problem, staying in the public sector while in many cases paying off loans in excess of $100,000.
I'm not personally familiar with a city program, but certainly the various law schools themselves often have programs where they forgive all or part of loans depending on years in public service.
Well, perhaps something that could be looked at for people who perhaps didn't have that opportunity at law school and now want to stay in the public sector.
Sure.
Thank you.
Thank you.
I'm going to ask another question, since I don't see somebody standing up. The question that Rick Schaefer asked about these long, old consent decrees like Jose P. and the homeless shelter cases, men's shelter, the family shelter, they're very old cases against NYCHA on evictions and other things of that kind. And I don't expect you to know these cases inside and out, but this is an area that I have worked in, and the cases, sometimes the agencies get very comfortable under these consent decrees, and there's never an opportunity raised to look at them again. And I like your comment about the courts being not a very good place for policy, but these consent decrees take on that aspect, and I would hope that you look at a lot of them that are now 40 and 50 years old in some cases, and are still driving policy. If you have a comment, I'd love to hear it.
Sure. I don't think there's a one-size-fits-all solution, but certainly in certain discussions with some agencies that have particularly in the social services side, very often the reason why more progress hasn't been made or there hasn't been the kind of change that you expect is just an absence of resources. You know, I mean, you have agencies that are being asked, you know, by legislators to do more and more with less and less, and the reward that they generally get is getting less and less to do more and more. And so when you see that, whether it's on the homeless side, whether it's, you know, it's in terms of the failure of resources is what is the greatest impediment to reform and change.
That's one of the reasons why the agencies like it, because they go to budget saying, I got a court order. That's the comfort level.
But here's the problem though, with where should the resources be spent? So you have a court order, right? You've got a monitor at some private firm. I came from a private firm, so I know that white-collar litigators There aren't as many trials anymore because of the draconian sentencing guidelines. They got to replace that income somehow. So now they're all becoming monitors. All right, they're all overstaffing their cases. Right. All right. And so when the victim agency is making that budget pitch, what's it for? To feed the process, to feed the beast of the decree, and not target it toward the reforms. If you can get the money focused on fixing the underlying problem, then the decree kind of takes care of itself.
I hope Peter Zimroff heard that.
Oh no, Peter shares my view of monitorships. I always believe that you should be planning your own obsolescence for day one. That's the whole point of a monitorship. Very good.
My name is Robert Brill. I didn't introduce myself before. In December of 2013, DNA Info was reporting a nascent dispute going on regarding the document retention and electronic document retention, including emails, of the city, and which was a policy, I guess, of the prior administration. And I was wondering if, a la your experience when you were at Justice Department, about how a lot of the Justice Department manual, a lot of public documents exist in which the Justice Department expresses its policies and its view of policies. Would you consider possibly the Law Department expressing on its webpage an official statement of the legal policy of the city regarding the retention of documents, the retention of electronic documents, and things of that sort? And of course, I'm alluding or talk in the world of, in effect, spoliation and how it plays out in litigation. And that way, when there's a public expression, everybody knows at least what the other side, or in general the city, has as its policy. No secret, public, out there.
Well, I think the trick is that, I think most of us favor transparency in the abstract until your ox is being gored. And so, obviously, we would support anything that consistent with other important values that increases transparency, and certainly having policies about disclosure would be important. But those things are currently under review. That has been a high priority for this mayor, and he has tasked his council in cooperation with the law department to take a look at that. Yeah.
Good morning. My name is Shannon Manigault, and I'm an attorney with the City Council. I was hoping you could speak a little bit more about navigating the kind of divide between law and policy and politics. I'm thinking very specifically of the role that the law department plays in kind of making sure that there is the appropriate balance of authority, balance of power between the council, the mayor, sometimes the comptroller, and historically where the law department has set out certain views in terms of that balance and how sometimes that might come into conflict now with the new mayor, both with the policy regime that he has in mind and perhaps also the political alignment that he has along with the speaker, where the law department may have historically, based on the law, stuck out a position about particular authority of the body, but because certain issues now, I'm thinking in particular of one instance with the living wage lawsuit, for example, where the law department had stuck out a position. Now there is a kind of change of authority in terms of who is making the calls, and how you plan to kind of navigate that.
Well, I think part of the problem, and it's a great illustration of why a courtroom is a poor place to make policy, because the executive policies were misaligned in the last administration with council, and there was tension. That gave rise to the city, the mayor, taking some uncomfortable positions in court that they may not have otherwise if they weren't trying to manage this policy agenda through litigation. And I don't want to get too deep in the weeds on that particular litigation, but that's an example of where once the city and the city council and the mayor got on the same page, then we could return to a position that was more traditional, more comfortable for the law department. I mean, we are generally not advocating that courts of appeals declare that our powers are preempted by other higher, potentially higher powers. So it's a good place to be back to. Yes.
Good morning. I'm Arthur Leonard. I'm a professor here at the law school, and another hat I wear is contributing writer for Gay City News, in which capacity I did an article about the victory of your department in the Second Circuit in defending the Board of Education's policy against holding religious worship services at city schools. The mayor immediately announced that he'd like to see religious organizations be allowed to hold the services. What role do you see for the law department in sorting this out?
Okay. Obviously, that is a case that usually you have First Amendment advocates in collision with people outside the First Amendment advocacy sphere. Here you have a tension between and among First Amendment advocates, because you got the free speech value component of the First Amendment in collision with the establishment cause. All right, and one person's free speech could, under some circumstances, be an imposition that's recognized under the establishment clause. What I think you have never seen in any statement from the mayor is an explicit reference to worship, though not to dodge. I mean, I think that it's certainly his position that under some circumstances, carefully tailored, it should be permissible, but the trick is to issue regulations from the Department of Education that ensures that to the extent that worship services are permitted on Department of Education properties, facilities, that they present zero imposition on anyone else who is not a worshiper. So, for instance, one of the problems that was cited during the course of the litigation is that, some religious organization would have a worship service on school property, and then the kids coming back would be confronted with the religious symbols still on blackboards, and the like, icons, sacramental, artifacts and the like. There would need to be somewhere near zero tolerance for that, because when you return to school, you shouldn't be able to tell that a worship service had occurred. So we'll be working through the specifics of regulations governing that, and we'll see how that plays out.
These will be the last two questions.
Morning. My name is Larry Levy, and I formerly worked as Assistant Corporation Counsel and a number of other positions in the government, including representing Ross when he was at DOT. I'm interested in your...
I'll speak to you about that.
You didn't go to jail, so there's nothing else to say.
That's my lawyer, right?
You know what they say about opening the door to a litigator. I'm interested in your comments about risk mitigation. Having been around the block a few times, you're not the first corporation counsel to have that view. There's always been a tension. Assistant corporation counsels, the corporation counsels see issues and try to get the agency to change their policy. There was a push at one time, instead of having all the money come out of a central claims pot, take it out of the agency budget when you get recurring events. That went nowhere. And when you meet with agency personnel and say, we keep seeing this pattern, the response is, yeah, but I don't have the budget dollars to fix it, or the bureaucracy can't move it. Have you come up with any methodology to get the agencies to be able to change policy, whether it's with OMBs shifting resources, short of having a consent order or front page news stories that the mayor is forced to respond to?
Thank you. I don't have a magic bullet for sure, but I think that one advantage that we have that we could probably exploit more is that the law department has a seat at the senior cabinet table, and all the agencies are represented through their deputy mayors. And to the extent that a recurring problem like this gets teed up to the level of the corporation council, then it's not difficult to share that with whichever deputy mayor has jurisdiction over that agency, so that you can get all the right people at the table to address it, including, it's also nice to have the budget director there too. And so it's, if you get the right people and you get, an indication that you have some plan for getting resources to address the problem, if it's a resource problem, there isn't always a resource problem. Sometimes it's just getting a concerted effort and get the right people around the table to address the problem, because in the long run, you're going to save money.
Thank you. I'm Steve Browdegam. I'm Assistant Commissioner for Legal Affairs at Sanitation, and delighted to have you here today. Question.
And I'm sure you're relieved that the snow has stopped.
Yes, we are.
Yeah.
We, all of us lawyers, get good legal training, but one thing we don't get trained at law school is management. And you've got quite a resume of senior management experience in the law firm world, and of course the public sector as well. And I wondered if you could share some thoughts with us about how to develop the skill set to manage other lawyers, and other kinds of suggestions you might make for those of us in agency counsel positions who manage staff and want to motivate staff and also have productive staff, given the limited resources we have in the public sector and the fact that we don't have the same metrics in private sector like billable hours.
Right. Well, it's first of all, I would hesitate to have anybody follow my example, because I am, as some of my senior colleagues might grudgingly attest, I mean, the example of being Peter Principal to positions of high management. No, but in all seriousness, it is a peculiar affliction of the legal profession and education, that you get really excellent people who do excellent work in a particular function, like teaching or trial lawyering or appellate practice. And because they've done really good work, they're rewarded with the opportunity to become lousy managers, right? Without any training, without any orientation, because one of the things about lawyers is that we kind of think we know it all. And so we kind of think that because, well, I've seen other managers do it or not do it, well, I can do that too without any training. I mean, I was on the board of directors of 2 public companies. And when you're going to promote somebody, you don't just assume they've got the skills, you give them the training. Police organizations are a lot better at that than lawyers are. The military is much better at that than lawyers tend to be. So, first of all, you have to get lawyers to accept that management is different. Management is even better than leadership, is even different from leadership. I mean, I think I have decent leadership capabilities. I think I can inspire people to follow, but in terms of organizing the task, that's something different. And that is something I think that people need to be trained to do. Just how to organize a task, how to organize people. Motivating is more leadership talent. But managing is something, I agree with you, there needs to be some training regimen either in each organization, or to the extent that organizations don't have the capability or the resources to provide that training, maybe the city needs to put together some sort of training program where you can send people who are about to be graduated into management. But it is something totally separate that I think that's one area in which, I mean, I don't buy this notion that the private sector is superior to the public sector in terms of how it does its job. I mean, I think the private sector masks its inefficiency in zillions of dollars. You know, I think the more often than not, government functions just as well as any private company I've seen. But where they tend to get it better than we do is recognizing that management is different. Yeah. Sure.
Hi, not a question, just a little segue. You gave me an opportunity. So my name's Stacy Cumberbatch, and I'm the new DCAS commissioner. And I started my career at the Law Department in 1986. And so I just want to give a plug. So DCAS offers a variety of training, including a management training. just go on the website. There's a lot of things that we offer to assist city employees to develop the skills to become managers, to do analysis, et cetera. So it's available already. Thank you.
Great, great. Good to know. Let me stay right here. Oh, sure.
Well, I want to thank Zachary Carter for a very stimulating morning and an opportunity to get and to hear. Yeah, let's have applause. There were so many topics covered, from very important things like stop and frisk to management. It's really interesting to hear your views and to get a sense of the man and how the leadership will be at the Corporation Council. So we're delighted you shared this with us. As we always do at these events, we like to give a product of the Scholarship of New York Law School, and this is the book by my colleague Jim Simon on FDR and Chief Judge Hughes. It's a wonderful read, and we present it to you with thanks and gratitude for this morning.
Thank you.
Thank you. We will see you in May.